5 seconds to go. Start. This court, in a catena of decisions, has granted relief against recovery of excess payment of emoluments allowances if the excess amount was not paid on account of any misrepresentation or fraud on the part of the employee, and if such excess payment was made by the employer by applying a wrong principle for calculating the pay allowance or on the basis of a particular interpretation of a rule order which is subsequently found to be erroneous. The relief against recovery is granted by courts not because of any right in the employees but in equity, exercising judicial discretion to relieve the employees from the hardship that will be caused if recovery is ordered. But if in a given case it is proved that the employee had knowledge that the payment received was in excess of what was due or wrongly paid, or in cases where the error is detected or corrected within a short time of wrong payment, the matter being in the realm of judicial discretion, courts may, on the facts and circumstances of any particular case, order for recovery of the amount paid in excess. Undoubtedly, the excess amount that has been paid to the appellant teachers was not because of any misrepresentation or fraud on their part, and the appellants also had no knowledge that the amount that was being paid to them was more than what they were entitled to. It would not be out of place to mention here that the finance department had in its counter affidavit admitted that it was a bona fide mistake on their part. The excess payment made was the result of wrong interpretation of the rule that was applicable to them, for which the appellants cannot be held responsible. Rather, the whole confusion was because of inaction, negligence, and carelessness of the officials concerned of the government of Bihar. Learned counsel, appearing on behalf of the appellant teachers, submitted that majority of the beneficiaries have either retired or are on the verge of it. Keeping in view the peculiar facts and circumstances of the case at hand, and to avoid any hardship to the appellant teachers, we are of the view that no recovery of the amount that has been paid in excess to the appellant teachers should be made. Similarly, this court in ITC Limited versus State of Uttar Pradesh and others held as under. We may give an example from service jurisprudence where a principle of equity is frequently invoked to give relief to an employee in somewhat similar circumstances, where the pay or other emoluments due to an employee is determined and paid by the employer, and subsequently the employer finds, usually on audit verification, that on account of wrong understanding of the applicable rules by the officers implementing the rules, excess payment is made. Courts have recognized the need to give limited relief in regard to recovery of past excess payments to reduce hardship to the innocent employees who benefited from such wrong interpretation. In the case of State of Punjab and others versus Rafiq Mashi, Whitewasher and others, this court held as under. It is not possible to postulate all situations of hardship which would govern employees on the issue of recovery where payments have mistakenly been made by the employer in excess of their entitlement. Be that as it may, based on the decisions referred to herein above, we may, as a ready reference, summarize the following few situations wherein recoveries by the employers would be impermissible in law. Stop.